Thank you all, and I want to introduce now our second panel of the day, which is going to take us from the federal TBORs to the state and municipal TBORs. And the moderator of this panel is someone who knows where the restrooms are in this building, because he actually went to law school here. And he, for many, many years, has taught as an adjunct in our graduate tax program, teaching the course on state and local tax. Great pleasure. Welcome back to the law school, Stu Weintraub, who is at Chamberlain Herdlicka here in Philadelphia. And I think of Stu as Mr. Salt, because he is a nationally known expert on state and local tax, and I'm delighted that he has put this program together and will now moderate it. So without further ado, and with apologies for the technical challenges that he's going to have to deal with in getting his slides to move, thank you, Stu.
Thank you, Alice. One slight correction. When I started here, this building wasn't built yet.
So you don't know.
Yeah, well, I do know from my teaching here. Okay, well, thank you very much, Alice, Chris, Andrea, for everybody who's put this program together. Our panel is going to be approaching the topic in a format-wise, in a different manner. Instead of having individual presentations, what we've done is we've identified issues among the group here that are common for the different states, and I'll introduce the panel in a moment. And I'm going to be posing questions to them, and each of them will then in turn be responding to the questions as it applies to the respective states and their respective perspectives. And you'll understand what I mean by that as I introduce the panel. And my introductions do not represent a political statement. To my left is Marlene Barnhart, who is chief of the Conference and Appeals sections for the New Jersey Division of Taxation. To her left is Young, who is the taxpayer advocate for the city of New York, and I hope I didn't totally destroy the pronunciation of her name. To her left is Peter Faber, who has been a dear friend of mine for many years now, partner in the SALT group at McDermott, Will & Emery in New York City. To his left is Tom Gosler, who is the acting chief counsel for the Pennsylvania Department of Revenue. And to his left is Catherine Cat Martin, who is staff attorney at CLS in charge of the Property Tax Foreclosure Group. And now let me run through these slides to get to where we're supposed to be. Okay. And this is the technical problem that Alice was alluding to. Okay. These are the issues that we've identified as the ones that we're going to be talking about during the next roughly 85 minutes. We're going to start out talking about privacy and confidentiality, one of the preeminent issues in the TBOR statutes and authorities. Then we'll talk about equitable powers that the various agencies might have. Talk about the right of the department to meet, the right of the taxpayer to meet with the department representatives, what the department must provide to the taxpayer, the power and independence of the taxpayer advocate. Whether administrative agency decisions have precedential value, the ability of the departments to issue advisory opinions, the right to request an advisory opinion by the taxpayer. What happens if the department has violations of the TBORs and what the taxpayer's remedies might be. Whether the TBORs are created by statute or administrative action and what the differences are. What is not in the TBOR and should be, what is not in the TBOR and what is not in the TBOR and should be, what is in the TBOR and should not be. Talking about applications of payments. This becomes the issue with respect to you make a payment and does the tax get applied to the tax first, or does it, and then to the interest and penalty, or does it get applied to the interest and penalty first? Questions like that. The power to abate interest and penalties, the use of leverage to assist when resolving disputes, and TBOR benefits, past and future. Okay. These are the citations to the respective statutes that and ordinances that we're looking at. In New Jersey, you have the Taxpayer Bill of Rights, you have a Statement of Taxpayer Rights, Procedures, and Time Limits, and the State Tax Uniform Procedure Law. New York State has a Taxpayer Bill of Rights, and New York City has a Taxpayer Bill of Rights. You'll see for New York City, since there is no legal citation to it, since it's an administrative policy that is posted on the New York City website. Pennsylvania has the Sunshine Act. It has a Taxpayer Bill of Rights as a state statute, the state statute for the Taxpayer Bill of Rights, which applies for state taxes. Then there's a local Taxpayer Bill of Rights, which applies to all municipalities in the Commonwealth of Pennsylvania, with one exception. And I'm sure you can all guess what that exception is. You're sitting in it. The city of Philadelphia does not have a Taxpayer Bill of Rights. And we'll talk about that as we go along. Okay, so let's start with privacy and confidentiality. Are taxpayer records confidential? Tom, you want to start us on that, for Pennsylvania?
Sure. Can everybody hear me okay? Yeah. I just start by saying, sort of echoing the statements of the folks that came before, just thanking Temple Law, Dean Mandel, Professor Abreu for inviting me to participate on this panel. It's a real privilege, and it's been great to converse with the other members of this panel in preparation for today. And thanks to Professor Abreu for now giving me your new nickname for any case that we have with you, which is you're going to be referred to as Mr. Salt going forward. Yeah, so to the question, and I guess just to start, I'll say, my thoughts, our participation here on behalf of the Department of Revenue is really just to give, it sort of echo what Dean Mandel said earlier. This is the part where I think is going to be more of a practical nuts and bolts view of the Taxpayer Bill of Rights and how it impacts the Department of Revenue and our interaction with taxpayers. So in terms of the privacy rights, yes, you do have a right to privacy under the Pennsylvania Tax Code. Section 731 of the Tax Reform Code provides that any information the Department of Revenue receives from a taxpayer is deemed to be confidential. And that's any information. That's not just a return. It's not just a response to a request for information from the department. It's any information that you submit to the department is deemed to be confidential, with really two key exceptions. The first is information that the Commonwealth of Pennsylvania can share with third parties related to the official purposes of the Commonwealth. So what does that mean? Well, the official purposes of the Commonwealth essentially means the collection, administration, or enforcement of Commonwealth taxes. The Attorney General's office had opined on that some years ago, and they said, well, yes, the information is confidential, but it can be disclosed to third parties if it forwards one of those goals. So what would be an obvious or a practical example of that? Sales tax on motor purchases. So we routinely share information with the Pennsylvania Department of Transportation related to sales of vehicles. We share information with labor and industry related to taxes that impact unemployment compensation benefits and things like that. So those would be some of the examples of an official purpose for us to share information with third parties. The other kind of exception to that is information related to refunds and credits that inure to either a corporation or to an individual taxpayer. That's specifically spelled out in Section 731. So those are the two key sort of exceptions to the general rule on confidentiality. And just a note, even the mere fact that you are a taxpayer in the Commonwealth is deemed to be confidential. If you contact the Department of Revenue and you say, I'd like to know if John Smith has been filing his PA 40s, we cannot provide that information to you. That information in and of itself is deemed to be confidential. So Department of Revenue takes that very seriously and tries to really narrowly tailor where and when we're going to share that information with third parties.
Marlene, want to tell us about New Jersey?
Well, New Jersey mirrors Pennsylvania. Our privacy, it's statute, it's section 5450-8, which is a confidentiality. As a employee of the agency, I am charged personally with, as far as browsing taxpayer records, you know, that is no tolerance, and I could be discharged from my position for that. So we take confidentiality of taxpayers' records very seriously. Even as far as a taxpayer just visiting the website, we have a privacy notice on there as far as if you do visit the website, your IP or address may get, but we're not going to do anything with it. You know, but privacy and confidentiality is very big with New Jersey. So when we take it very seriously.
Peter, Peter, would you like to comment on New York?
Yeah. The official policy in New York State and New York City is to preserve taxpayer confidentiality, and indeed employees of departments could get in real trouble if they breach that. In fact, my experience as a practicing tax lawyer is that they go overboard because the standard closing agreements that both the state and the city use absolutely forbid the taxpayer from disclosing the settlement to anybody, including their lawyers, to get advice on what the closing agreement means. And we've been able to negotiate, exceptions. The problem that we have, though, is that in New York State, we have a False Claims Act, which applies to taxes. Very few states do that. And the False Claims Act empowers the Attorney General to enforce the tax laws. And I've always felt that the letters AG stand not only for Attorney General, but aspiring governor. They're really looking for publicity. And a False Claims Act examination in New York does not end up with a confidential closing agreement. It ends up with a press conference. And the name of the taxpayer and the dollars involved will appear in the Wall Street Journal the next day. So that is a major problem that's been presented. Now, obviously, most audits don't involve False Claims Act issues, but a lot of them do. I've got 3 now that involve that. And that's a major, we found a practical problem. We try to negotiate in settling with the AG the extent to which taxpayer information can be disclosed. But they want to be able to say in their press release that we just collected $30 million from company X. So it's a real problem.
Okay, then I'm gonna go further in New York City. Like Peter said, it is generally the policy of New York City not to disclose. But when it comes to property tax, the property tax payments and the bills are publicly available. So you could log on to someone's BBL, that's called block and borough and lot number, or you can look by the address, and it's a public information. But some of the information is not disclosed. Like, for example, the payment information would not be available for public, but you could see how much they're being assessed, what exemptions or anything that's attached to that property. You could see it. It's available in public domain. For business and excise tax, we have the New York City admin code that forbids disclosure. But like Peter said, there are some exceptions depending on where you are with certain procedures that we could share with third party, very, very limited way. And I think as we are going through this agenda, we're gonna talk about when it is, then I could talk about that.
Yeah, I guess did you want to jump in? I was just going to add one point in regards to that, and in regards to the idea of public records. In the Commonwealth of Pennsylvania, part of our collection and enforcement administration in years past centered around actively going to the courthouse to file paper liens against taxpayers. And obviously, if you file a lien with the Prothonotary office, that's going to be considered public information. Our code was changed years ago to sort of eliminate that process entirely. We used to have to not just file the liens, but you would have to go and recertify them every 5 years. So that requirement was done away with. And so instead, really, the department relies upon a statutory lien. But it leads to interesting results when a taxpayer is seeking information in regards to whether a taxpayer has a lien filed against them. So you could go to the Prothonotary's office and conduct a search and say, well, does business ABC have any liens filed against them? And if there was nothing actually filed with the Prothonotary, it's going to show up that it's clean. Conversely, though, there may be a statutory lien against that taxpayer. They may have missed filing requirements, they may have missed payment requirements, and that statutory lien would be reflected on the department's system as showing that they have an outstanding liability. So it's just something to keep in mind, in terms of the interplay between some of these public and private records.
Kat, you want to respond on Philadelphia?
To echo Young Chong, in Philadelphia, all the property tax liens are going to be a public record. You can look up who owns a property. You can look up what the property is assessed at. You can look at if they have exemptions on the property for various reasons. It won't give you the reason for the exemption, but you can see the amount and you can infer what the reason for that exemption is. You can also look up on the revenue website what years of taxes are owing, what the principal was, interest, penalties, attorney's fees. You can see where payments have been made by looking at this. You can also see who the tax collection agency is and whether that person is in a payment agreement for any given year. So while the city does take an approach that taxpayers are entitled to privacy, and they have made that clear, with us as advocates in conversations, there is also a vast amount of information that is publicly available.
Okay, let me just supplement what Katja was just talking about. There is a Commonwealth Court decision, City of Philadelphia versus John Doe, in which the city actually brought suit under the Declaratory Judgment Act back in the 1970s to get the court to confirm that the delinquent tax information, this is why it's now on the website, is public information. In the city, in the Philadelphia Code and in the city's Department of Revenue regulations, there is specific provision. This is non-property tax. This is for the wage tax, the gross receipts, the business tax, all the business taxes, and the myriad of other taxes that Philadelphia imposes, that taxpayer records are confidential. And the department does take the confidentiality issues very seriously. In the local taxpayer Bill of Rights, again, there is a provision for confidentiality of taxpayer records. As Tom was talking about, the municipalities take the same position as Pennsylvania, that even the identity of a taxpayer is confidential. And I was litigating an issue over just that, whether the taxpayer's identity is confidential, and it was a question came up in a discovery dispute, and we actually got in Montgomery County, a discovery master issued an order that the identity of the taxpayer had to be disclosed to us, of other taxpayers had to be disclosed to us, and if not, the municipality would not be permitted to pursue the defense that they were seeking. So in that context, we were able to, what shall we say, get a court order to breach confidentiality. Next question is, each state and locals have administrative appeal processes. And the question is, during the administrative appeal process, are those hearings public and are their decisions public record? Who would like to take that one on first?
I'll start, I guess. I would say in Philadelphia, it very much depends. It depends on which administrative agency the taxpayer is appealing to, and also what the format of that agency's appeal process is. There are informal review processes within some of the agencies, so you can informally appeal an assessment to the Office of Property Assessment. You can informally appeal certain aspects of a bill to the Department of Revenue through a process that's called a first level review. This process is entirely informal with regards to the Department of Revenue. It is not actually in the code anywhere. You just kind of have to know that you have this right. All the more reason why Philadelphia should have a local TBOR. And so in those cases, though, they're frequently not even any sort of forum. It's frequently just decided upon a written record. You make a written statement, you provide some documentation saying that things should be changed. These are entirely confidential still. They're in no way public. At the same time, you can have an appeal to the Tax Review Board over a denial by the Department of Revenue for certain programs, or with regards to interest and penalties and a few other things that they have review over. And there's 2 levels of review at the Tax Review Board, in which the first level is in front of a master. There is no recording, there is no stenographer, it is completely off the record, and they are technically open to the public. However, frequently the masters who sit over these appeals will shut the door and try to deny the public an opportunity to view these. At the same time, if you don't like what happens there, you can appeal to the full board, at which point it is on the record. Of course, obtaining those records can be difficult, and those, again, should be open to the public, but sometimes doors get shut. And so I would say in Philadelphia, where we are operating under, where we don't have a Bill of Rights, and yet there are some rights enumerated in various places, whether it's in state statutes, whether it's in the Philadelphia Code, regulations, administrative rules, people don't always know what they are. And so it can be very difficult for a taxpayer to know which forum to seek review under, and also whether it is going to be public.
Just to echo that for Pennsylvania, I'm assuming most of the audience has familiarity with our tax appeals process, but if you don't, your initial petition for assessment or petition for a refund would be filed with the department's Board of Appeals. Now, that's an administrative appeal board that's actually part of the Department of Revenue. We really sort of look at the Board of Appeals as really a second set of eyes on an assessment or an action that's been taken by the department. Much like Kat said, they're not a record board. You're going to go there. You're going to meet with a hearing officer. They're going to take information and create a file, but it's not technically a record. Appeals from the Board of Appeals go to the Board of Finance and Revenue, which is a standalone administrative board. And we could talk more, I guess, some of these other questions about the history of BF&R, but BF&R now is a separate standalone board. The department used to have a seat on that board. We now are just a party. So BF&R holds hearings, and taxpayers bring their appeals from BOA, and in addition, a DOR goes as a litigant, and of course, appeals from there go to the Commonwealth Court. At the BF&R level, that's obviously, I guess, stepping back, BOA, because it is a board within the Department of Revenue. In our mind, it's a complete review by the department of that particular case, and therefore we deem those proceedings to be confidential. So we're not going to release any information related to a BOA hearing or a submission or a decision in order of the Board of Appeals. When it gets to BF&R, the rules are a little bit different, and so there's been some controversy really in the last year or so involving matters that are brought before the Board of Finance and Revenue, in that BF&R, which is now under the state treasurer, took a position this past year that proceedings before BF&R are subject to the Sunshine Act. And accordingly, they're essentially public meetings, and therefore all information related to those hearings are disseminated to the public. And so in line with that, what they started doing, I want to say, was it February or March of last year, they started recording the hearings. Now, personally, I didn't think that was that big of a deal, simply because even prior to videotaping the hearings were public. If you wanted to go to a BF&R hearing, you would drive over to the office and you would sign in, and you could sit and listen to whatever cases you wanted and find out as much information as you wanted about the particular matters. But now the recording of the hearings has caused some consternation, I think, within the tax bar. There was a fair amount of debate within the bar. I believe the tax bar took the position that the hearings were not subject to the Sunshine Act and therefore should remain confidential, but I'm not sure if the bar itself took a position. Did they vote on that? I don't recall.
Well, the Philadelphia Bar Board of Governors did not take a formal position on it. I can't speak about the Pennsylvania Bar.
Yeah, and the Department of Revenue has essentially remained neutral on it. I think you can make arguments for and against it. Certainly to the extent that a taxpayer may be raising a legal argument that touches upon truly proprietary information. Maybe it's a patented business process or something like that that comes into play as part of the appeal. I think the taxpayer has a right to go to the board and say, this should be an in-camera review, this should be a deliberation through an executive session, something like that, in order to protect that proprietary property. But our experience has been that that's not really the case, right? I think for the most part, if I had to be cynical, I would say that I don't think some of these taxpayers that are bringing sort of these annuitized refund claims year after year want to have that information more widely disseminated. And as a member of the board once said, pigs get fat and hogs get slaughtered. And I think there's a little bit of interplay there with the bar that there's an unwillingness, I think, to have any sort of public scrutiny to some of the cases that BF&R sees time and again. I mean, when the Department of Revenue looked at it, a deliberation under the Sunshine Act is essentially a discussion of agency business held for the purpose of making a decision. I don't think that there's any other way that you can construe the Sunshine Act but to find that an appeal brought before the Board of Finance and Revenue is in fact a deliberation and probably should be subject to the Sunshine Act. How that interplays, though, with the confidentiality rules under our statute, that's tough, and that's something that taxpayers have to take into consideration.
Yeah, well, I agree. Tom, I agree with you that I think it should be subject to the Sunshine Act. My problem is you can't pick and choose which provisions of the Sunshine Act you're going to comply with. They do not comply with the provision of the Sunshine Act concerning their deliberations and decisions. Those they maintain are confidential. But under the Sunshine Act, they have to be made in public. And if they're going to say that they're subject to the Sunshine Act, then they have to make those decisions in public as well.
Yeah, that's a fair point. The actual deliberations of the board themselves are not conducted in public. They are conducted in an executive session. And, I think my experience has been that their decision and orders are usually a couple days after the hearing is held, and there is not any public discourse related to their actual deliberations. And to my knowledge, that's not something that the Treasurer's Office has addressed after issuing their position on this. So it's something that I think they may end up reconsidering at some point. So we'll see what happens.
New York, New Jersey had.
I cover New York City because New York City, like I mentioned earlier, we have property tax issues separately. Then we also have business tax issues. And the way you appeal property tax issues different than the way you would appeal business tax issues. And then let me kind of give you a little background on how New York City classifies the properties, because that's going to matter whether or not you request for certain review. So most of the properties in New York City, and New York City consists of Manhattan, Staten Island, Brooklyn, Queens, Bronx. So all 5 boroughs, any properties within those 5 boroughs would be classified as either Class 1, Class 2, Class 3, and Class 4 properties. And within each class, there are subcategories that would kind of dictate how the property is going to be assessed and how they're going to be taxed, and different exemptions and abatements that are available for those classes. So you have all these issues, right? So when people usually get their tax bill, they don't know how to proceed, especially for homeowners. Class 1 are single-family homes up to 3 units. So they often struggle. Even Class 2, the condo owners, co-op owners, they don't know how to proceed. They don't know the difference between how do I request for an update, how do I challenge the assessment, how do I ask for clerical error. Sometimes they think one is another, so there are different process actually for if they want to just challenge because there's misdescription in their property, where we list their property as 1,000 square feet, but it's actually 800 or 700 square feet. So that's going to matter on how much they're going to be assessed, right? So the process is called RTU, request for an update, that is corrected. Then there is a process that where you don't agree amount of taxes being charged, right, assessed, and that is called request for review. And oftentimes people don't even know that there are certain due dates that you have to apply, and usually request for review goes to tax commission. So, and it has to be filed by due date, and then it also talks about different process that you could take your claim. Like even you get benefits exemptions denied, then you have to apply using particular forms to tax commission. Then if you get denied, then there are different appeals process. So because a lot of taxpayers, and I think this fundamentally violates their right to know, their right to be informed, right? And their right to pay no more than the amount of tax that they should. So what we did is we had to create a brochure just on, like, for example, here, property tax appeals. So we outline, what do? I got this. Do I ask for review, request for review? Do I ask for request an update? Do I ask for clerical? Then what next? You know, after you file certain forms, and we tell them what dates that they have to file, what forms they need to, the websites that they could go access those forms. And what happens after they appeal? For example, if they went to tax commission, what happens? And different process that they could go through, even all the way up to taking it as the Articles 78. You know, it's a judicial process. That's the final appeals process. That's just on property. Okay. Then for business tax, there's a different process. And it matters whether or not it's in collections, is pre-assessment or during the assessment period, and one that's post-assessment. So we created a brochure again just for before post-assessment, because there are different processes that they need to be aware of. I mean, usually for New York business taxpayers, you know, New York City is a big city. So for business taxpayers, they tend to be big businesses. So they are usually represented by their CPAs and attorneys. So they are well represented. But once in a while, we do have small business owners, or sometimes we work with representatives who are coming and trying to resolve some of their issues through the Department of Finance, but they're not getting anywhere. Or they want to look at some different options, or sometimes even during audit. And technically, we are not supposed to be involved during the audit process. That's one of the agreement that we have. But you know, occasionally you do have to get involved, because even during the audit, especially if you want to limit the look-back period for some of the different taxes. New York City has what we call it unincorporated business taxes, general corporate tax, business tax, bank tax, and other excise taxes. And then there are transactional taxes like real estate property taxes issues, and also sometimes real estate property income and expense statements that you're required to have. And then there's commercial rent tax that's only available in Manhattan. So you have to know all the different rules and how they work. So I don't want to take up more time, but there are different processes. So depending on how you approach it, you get the right review. But on the other hand, if you miss it, then obviously you don't.
New York
Let me
State.
comment on, actually expand a bit on this too, because I think we're, you know, in terms of confidentiality and what is public. I can't speak to property tax, that's a different word.
Right.
I don't get into that. But in terms of the business tax, personal income tax, generally if you can, an administrative proceeding with the auditors is wholly confidential, it's totally private. If you decide to litigate before the city or the state tax appeals tribunal, the filing of the papers, the hearing itself, are not public matters. The first time it becomes public is when there's a written decision from an administrative law judge. At that point, the decision will say everything. It'll include details about your income, your expenses, whether you've been divorced. I mean, it's totally public to the extent anything's relevant to the tax determination. And that, frankly, is an issue for some of our clients who either don't want information disclosed to the public in a decision, or, and in some cases, we've had situations where clients did not want the fact that they were litigating a tax case to be public for a lot of PR reasons. So, but in New York, generally, you are safe from disclosure until there is a written administrative law judge decision. But at that point, it is totally
Can a
public.
request be made to the ALJ to redact confidential information? So,
You can ask an ALJ to do that. They don't have to. I have, generally in personal income tax cases, they don't do that. The one situation which I've seen is, and was mentioned by Tom, is where you have trade secrets, things like that, and they very often will agree to redact that.
New Jersey?
Well, New Jersey, as far as any actions by the Director of Taxation, and that would be as far as any delinquency, deficiency, collection and enforcement issues, assessments, individual or business assessments, and then you have refund request denials. Those, all those notices come with protest and appeal rights. So within that, you have, and this is where my branch comes into play, the Conference and Appeals branch. If you decide after the action that you disagree, you have the right to protest. And that is at the agency level. My group will, we have an informal administrative hearing. It is a private hearing, just for the taxpayer and designated representative if you have one. They're not recorded. They can be recorded if the taxpayer does request, and there's a process as far as recording. They are not public at all. They are confidential, and for that specific taxpayer, after the review, a final determination is issued, and that is also private, specific for that taxpayer. And from that, if you still disagree, you have the right to go into tax court with that. As far as local property, my group does not handle that, but it's also, they have an avenue as far as, I believe, you start with your municipality, and then you go through the tax board appeals, and then you also at the end can end up in tax court. So there is a separate route for local property.
Okay. Many of the states have entered into agreements for information exchanges. Is there a statutory basis for this, or what is the legal basis for exchanges of information which may be confidential within the state?
I could just speak to, as to Pennsylvania, I go back to Section 731 of our fiscal code, which allows us to disseminate information as long as it's for the official purposes of the Commonwealth. The Attorney General's office has essentially said, as long as it furthers the collection and enforcement or the administration of your state tax, you can share that information with other jurisdictions. So that served as sort of the legal justification for us sharing information with other states or working through folks like the MTC and things like that.
New Jersey, New York?
We're the same.
Yeah. Just an example of this, and this is a case that I got involved in many years ago. A client of ours went in New York City, bought two pieces of artwork from a major art gallery, had the artwork delivered to his home in Bucks County, so they didn't have to pay the New York State sales tax on it. But they then got a notice from Tom's people. Well, this is before Tom, though.
No, I was there. Well, I remember the case.
Got a notice from the department. Well, you owe Pennsylvania use tax. And, there was no question that he did owe Pennsylvania use tax. We just had to just work out whatever we could, to pay it. I mean, it was a significant amount of money because these audits, which is information, I don't know if it's a matter of policy or under the terms of the agreement, it was significant purchases. These were art galleries, jewelry stores, going to Tiffany's or Cartier in New York and buy some diamonds. I mean, there was actually a case a number of years ago, I think it was Cartier. They were actually shipping empty boxes to the customer's home, and the customer would take the jewelry with them. And there were criminal charges filed in that case in New York. But these are the shenanigans that were going on to try to avoid the tax, and the information exchanges helped somehow reduce those shenanigans. Okay, let's talk a couple of minutes about equitable powers. You know, within the departments, these taxpayers' Bill of Rights and the statutes themselves offer the agencies and the departments and various equitable powers. Would you like to talk about them? You know, Tom, you want to start on that one too?
Yeah, sure. Under Pennsylvania's TBOR, is the question whether or not the Board of Appeals has that, or whether
Board of Appeals, Board of Finance and Revenue?
Yeah, so I could speak more to the Board of Appeals. Like I said, it's an independent review of a department action, and we've really viewed them as just sort of a second set of eyes. Practically speaking, what they end up doing in many cases is correcting a lot of math errors, transcription errors maybe that our tax examiners make, and so that provides a bulk of the work that BOA does. But in addition to that, they do exercise certain equitable powers. There are circumstances where, particularly where you're confronted with a pro se taxpayer, where jurisdictional issues would be waived. And I know BF&R will do that as well. The departments went out of its way, I think, to honor the spirit of our TBOR, which suggests that those are the sort of actions that we should contemplate when you're dealing with taxpayers who don't understand the process. I mean, in Pennsylvania, essentially you have 3 de novo reviews with their own set of rules for a tax appeal, which is kind of incomprehensible to me, and it's a nightmare to have to, as an attorney, to deal with that. But I can't imagine what it's like for a taxpayer to come in without any real understanding of that process. So all I can say is that, generally speaking, that's sort of in the background of how BOA looks at their cases, and I think BF&R as well.
Now, I've had many cases where it was predominantly New York accountants, but it's from accountants all over the country. They may have a client with a Pennsylvania problem, and they don't know the Pennsylvania rules, and notwithstanding the fact that the notices have the appeal rights right on them, they blow the appeal deadlines. And, you know, after they've gotten denied at the Board of Appeals, I might get involved and try to ask the Board of Finance and Revenue to exercise its equitable powers, and it's basically been uniformly turned down. They say, well, the notices had the appeal rights on them. Why should we exercise the rights? In which case, I then tell the accountants to notify their malpractice carriers. Is there any equitable powers that the agencies have in New York and New Jersey?
Yeah, well, there are, and in every state, the tax department has an equitable right to adjust the manner in which a multi-state company, apportions its income. But one thing to keep in mind is that there is case law supporting the view that if a revenue department has equitable powers, it has to make a good faith effort to get to the right answer. And there's a wonderful case out of Utah just decided this month where the Utah Revenue Department had the power to adjust the income of a multi-state company to require arm's length dealings with affiliates, which is a very common equitable power that state revenue departments have. But the revenue department in Utah simply arbitrarily reallocated income from one company to another. They had no basis for doing it, and they ignored IRS regulations dealing with an analogous area. And the Supreme Court of Utah slapped them down and said, you have an equitable power, but you have to make a good faith effort, and you have to support the basis for exercising that equitable power. We had a case a few years ago where the New York law at the time provided that income of a parent corporation from a subsidiary was tax-free, or could be tax-free in the discretion of the state tax department. Didn't have to be, but the department had the discretion to make it to disallow expenses relating to that tax-free income from the subsidiary. didn't say that expenses relating to a subsidiary were automatically not deductible. It said the department had the discretion to disallow the deduction. And I remember cross-examining the auditor in that case and saying, well, how did you decide to disallow the deduction of the parent for expenses relating to the sub? And he was flummoxed because he arbitrarily just disallowed it with no basis. And the Tax Appeals Tribunal held that that was improper. So you do have a right as a taxpayer to put it to a revenue department and to insist that when they have an equitable power, that they make a good faith effort, given the reasons for that power, to get to the right result.
I guess just to follow up on that point, a question, I guess, for the whole panel. In Pennsylvania, we have a regulation that allows a taxpayer to challenge the methodology used by our auditors. If you don't challenge that methodology and it results in an assessment that you believe is erroneous, can you then raise that issue on appeal, or are you precluded from doing that?
In New York City, for example, for property owners, they could go to tax commission because that's supposed to be an independent entity, and they could decide whether or not there was a correct assessment made. And they could actually command Department of Finance to make the adjustment. So we do have taxpayers who are going back, each year. Actually, it's each year. You would think sometimes when they decide that's kind of going forward, but obviously that decision is only for that particular application, meaning limited to that year. So they do have it. And in cases where there were errors and taxpayers didn't exercise their right to petition in a timely manner, and there are, especially if you could fine for taxpayers due to clerical error, New York City does have it. It's a recent thing where the commissioner will exercise his discretion to make the adjustment, and he has. And our office has used that clerical error exception as a way to overcome the deadlines that the taxpayers miss, to go back and address some of those issues for property owners.
Okay. Next question is, when a taxpayer would file an amended return, does that substitute, well, let me go back with one question. Must that amended return be processed? Or is there discretion on whether or not to even accept the amended return?
Well, I know the state of New Jersey, as far as even if my group would receive an amended return, we're going to make sure it's processed. It's just what we do, and we're required to process it.
I would say from the Pennsylvania perspective, I think you have an obligation to accept it and process it. But for the only example I can think of where that wouldn't apply would be inheritance tax, where you don't have the ability in Pennsylvania to file an amended return. You just file an original, and you would file a supplemental return for additional debts and deductions or assets that you discover later. But it's an interesting question, and we do come across this, and it has raised TBOR issues where taxpayers will the Department of Revenue would routinely stock shelves at post offices and other public places with our tax forms, and then as tax forms are updated, occasionally the old forms still remain there. Well, if you utilize the old forms, in many cases when they're filed with the department, we can't process them. They go through our scanners, and our scanners don't read them. So the question becomes then, you have somebody sitting out at an imaging facility who's received a return that was filed right at the deadline, and they're looking at this return and they're saying to themselves, well, I'm pretty sure I know what this taxpayer meant to do. It looks like they just used the wrong form. Do I key punch that in? Do I manually import that information into our system and accept that as their return? Or do you reject it and you send it back and potentially subject that taxpayer to late filing penalties? I would, if you asked me that question a year ago, I would have said, now you got to send it back and tell them that they did it wrong. What I found out recently was that the department does not do that. They, in fact, in an effort to be taxpayer friendly, will accept those returns And to the extent they have to key in any data into the system, they'll do that and then take the misfiled return and sort of attach it in a file with that so that an examiner could have some rough approximation of what the taxpayer was trying to do. I think that creates its own set of problems. But I think to answer the question, yeah, Pennsylvania would accept it.
What about the amended return now, as far as where a refund is being sought through an amended return? Does that substitute for a refund petition to toll the statute of limitations, or must you still file a refund petition, timely?
We actually had this case a few years back, and the answer is that amended return does not substitute for a refund petition. It was the Quest Diagnostics case from, I think, 2015. Essentially, Quest, it was a capital stock franchise tax case, and Quest had filed a return, I want to say, in third quarter of 07, reported their tax, paid their tax in full, and then confirmed that tax on their next quarterly filing. They then came in about a year later and filed an amended return and argued that certain deductions should have been included, and therefore that would have generated a refund. So that sort of set off a period of a year or two of review by the Department of Revenue to that particular taxpayer. Information was exchanged back and forth, and eventually the department came back and said, "Now we're rejecting that return," and then that led to an appeal. Essentially, the taxpayer raised a number of arguments, but their argument was twofold. They said basically, well, that supplemental, that amended return, in essence, acts as a refund petition. You're getting the same information. You should just disseminate that, and if everything lines up the way we say it lines up, it should result in a refund. And it went up to the Commonwealth Court, and the Commonwealth Court rejected that argument and relied upon a department regulation that I thought was fairly clear in stating that it can't substitute for an actual refund petition. As a corollary to that, the taxpayer raised a TBOR argument, and the court fairly quickly dismissed that as well and said, the bottom line under Pennsylvania's TBOR is it doesn't excuse a taxpayer who fails to comply with clear statutory requirements, which in this case was the 3-year statute of limitations for refund cases. So it ended up essentially it was a favorable decision for the department in that we got the court to basically say you have a statute of repose. It's not a statute of limitations.
Yeah, I don't see this as a TBOR issue. I mean, there are statutes of limitations on claiming refunds or filing amended returns, and they apply. And I just don't see that as a TBOR type issue.
Well, it becomes a question, though, of notice. If it's not a substitute for a refund petition, having to somehow notifying the taxpayer that it isn't, whether it be by regulation or an individual notice or somehow letting the taxpayer know so that they can take the appropriate action.
And the taxpayer did raise that argument, and our response was simply, we have a regulation. You have constructive notice of that. It was fairly clear, and the regulation was fairly clear that you couldn't do that. So,
Okay.
I would say, sorry, in the property tax concept here in Philadelphia, you have to formally ask for a refund. Obviously, there's no amended return situation, but you have to file for a petition for a refund. And it's incredibly problematic because if you go on the publicly available website and see, oh, I overpaid last year and I have a credit, you have to affirmatively request that refund. It will not in any way reduce your tax bill for the next year. It will sit there and it will show that you have a credit. And if you think, oh, I have a $300 credit for last year, I can just write a check for $300 less for this year. In fact, you will be $300 short for this year and you will start earning interest and penalties on the amount you did not pay. So again, these issues, I think it is a TBOR issue because I think people need to be aware of what their rights are with regard to refunds so that they are not paying more than the tax they actually owe.
I want to cover about the New York City. Actually, New York City used to do something like yours, where if they had a refund due, it'll just sit there. And the worst part of it is it'll sit there till 6 years, and after 6 years, whatever it was, you will lose it because you did not file. And one of the craziest things that happened was that they didn't give any notice on the notice. I mean, now they do. They put the notice, and the only way that the taxpayers would know how to claim a refund is to go online, and you got to know you're due a refund, right? So now at least they made a big improvement. They're putting the notices on the bill itself, when there's a balance due, that they have to petition for refund, and then they have, or they could offset it against the other one, but they have to request it. So it doesn't happen automatically. So we did have some taxpayers still thinking, oh, I have refund, and my tax bill is $2,000, I have $1,000, I'm going to just put $1,000. No, it doesn't work that way. They're still short. So they have to take affirmative action. So we are trying to work with Department of Finance to make the notice more clear. I mean, it's a lot better, but I think there's definitely room for an improvement. So that's with property tax. Then on the other side, on the business tax, we had an occasion going the other way around, actually. Generally, I think New York State requires if you file an amended return, you have to do it within 90 days. But where there is a occasion where you are audited, for example, and there's an adjustment made at the federal level, then you're required to, I guess, file an amended return at the state level. And if you are subject to the city tax, you're required to file. And where they run into problems, New York City has a UBT tax that covers a lot of sole proprietors and single member LLCs and partnerships. You usually get a different treatment at the federal and state, but under the city, if your income or the gross receipt is above certain level, then you become subject to UBT. So if you're subject to UBT and there's an adjustment made at the federal level, you are required to file an amended return. So we had a case where actually we were working with an LITC clinic. They came to us because they couldn't get, they had a client who got an innocent spouse relief at the federal level, and they got the innocent spouse relief at the state level. But because city, we do not administer personal income tax at the city level. It's done at the state level. And because we don't have any quote component of personal income tax other than those people who are subject to UBT. So, and she is subject to UBT because they're personally on hook for all those tax debt, where she got relief from the federal, but state, and now she's still stuck with this huge bill from the city. The only way that actually we were working with the LITC is that provision that requires you to file, because you have a requirement. So if you did not, it's treated as not file return, actually. So what we did is we asked the clinic to go back and file the return, because under the statute, I forgot the section, the code section, since the taxpayer has an obligation to file, that filing a return with adjustment should wipe out all the tax, because the federal adjustment innocent spouse was made at the federal level. So it hasn't come to our office yet. I mean, back to our office yet. So I'm kind of interested in seeing that.
Okay, I'd like to move on to some next question. We're starting to run out of some time, and we have a lot of questions yet to go through, so I'm going to try to move quickly through them. Okay. The next issue is on the right to meet with the department. What are a taxpayer's rights to sit down with a face-to-face with the representatives of the respective departments? Ronald, you want to start with New Jersey?
Yes, in New Jersey, you have the right to meet. It's part of the Taxpayer Bill of Rights. And it's the common practice at the end of an audit, whether it be an individual, office, or a field, you have the right to an exit conference. And that typically can be in person, especially for the field. And you can request to meet at any part during the process with a division representative, whether it be the auditor supervisor or, say, chief of the department, but that right is clearly available to all taxpayers.
It's essentially the same.
It's still the same.
Same in Pennsylvania, and in addition to that, you have a right to a written explanation of the action that the department took, along with instructions related to any potential in-person interview with the department.
Yeah, the New York State Tax Department has a printed form. It's a one-page form that they give any taxpayer at the beginning of an audit that lays all this out, including the right to meet with department reps.
I think the city uses it. It's a palm card that
Yeah,
they list
yeah.
that, yes.
Okay, anyone who has been in private practice or on the taxpayer side and has been involved with a governmental audit has encountered what I've called a rogue auditor. One that totally ignores policy, ignores procedure, ignores the law. Question is, when you encounter one of these rogue auditors, what do you do under the TBORs?
Interestingly, Pennsylvania's TBOR specifically states that you can't utilize the TBOR for any criminal matters or matters that involve the integrity of a department employee, which I think is sort of interesting. But I actually asked our taxpayer advocate, whether or not they take those cases, and they said, yeah, you'd be surprised. That's a big portion of them. It's taxpayers who just feel that they've been treated unfairly through in individual dealings with the department employees. So regardless of what the statute says, if you raise that issue with our advocate, they're going to take that case under
Same thing with
consideration.
New Jersey. Yeah.
And we have it on our taxpayer bill of rights, right to challenge the Department of Finance and right to be heard. So under that theory, they could come and, you could talk to the supervisor, the head of the division, could take it up to even to the commissioner and say, there's a rogue auditor out there.
Part of the problem is I find very often taxpayers, particularly corporate people, are offended by an auditor. It's not as if the guy is doing something dishonest or anything like that, but they disagree with him. They've had him before. He's always hostile. He's always aggressive. And as a practical matter, it's hard to do much about that, to be honest with you. If the person's clearly violating the law, that's one thing. If it's someone who's just overly aggressive, which is what I see a lot of, you can talk to the supervisor. You can ask to get a new auditor for the next audit cycle. They'll occasionally accommodate that. But it's tricky and it's dangerous because you may get the person the next time around. And it's difficult to deal with. No easy answer.
Okay. Next issue is access to department documents. Now, during the course of audits, what rights does the taxpayer have to documents within the department's possession? During the course of the audit, what rights does the taxpayer have? If there are, give an example, how about the audit manual? Does the taxpayer have a right to see what the audit manual is that the auditor is operating under?
Sure. I'll
Go
take
ahead.
that one. The state of New Jersey, actually on the website, and this came into play in March of 2017, posted the New Jersey Manual of Audit Procedures. So it is clearly there for all to see, accessible. And then, of course, too, if you're going through an audit, you can, I guess, if you would want to challenge the auditor as far as what they're doing, methodology, procedures, you have that right.
I think this is an area where you want to look not just at the TBOR, but at the state's Freedom of Information Act, if it has one. Because I know my experience has been you can usually get the audit file of that particular company or individual. The question is, can you get internal memoranda dealing with the substantive issue that might involve other companies or other taxpayers? And there, typically, a Freedom of Information Act would have an exemption from disclosure for confidential material relating to particular taxpayers, but very often there are a lot of internal research memos that you can get through the FOIA that you wouldn't necessarily get under the TBOR. And we routinely file requests like that in audits.
And ultimately, that led the department to change its policy. I confirm that, much like New Jersey, we have our manuals now online, and it was really a direct result of a right-to-know request that we got.
What about, I think that Peter alluded to this, if the department has issued a private ruling in a case unrelated to this particular taxpayer, but it addresses the same issues that are facing this taxpayer, does the taxpayer have a right to have a copy of or to understand and know what's in those other private rulings? New York, New Jersey, Pennsylvania, anybody?
We grappled with that a little bit and ultimately decided it was in the best interest to just simply post all of them on our website. I will say we don't issue nearly as many private letter rulings as we have in the past. My personal thought is it ends up being a CYA letter for practitioners, and I just assume us charge to do them. But we don't. So we don't issue a lot of them, but they are on the website and accessible to taxpayers.
Tom, do you redact the names of the taxpayers?
We do.
Yeah.
Yes.
Because I know New York publishes, when you should get a ruling from the department, it'll be published, but with the names, identifying information redacted.
You know, Tom, I would agree with you that a lot of times it's a CYA for the practitioner. A lot of times the client will say, well, can we get a ruling from the department, to say that what we're doing is correct? And they're looking for that basically for penalty protection issues. And you made a comment about just going to be paid for it. Look at the Philadelphia Code. Philadelphia does charge for private rulings.
You can get a ruling from New York State if you're willing to wait 2 or 3 years.
And New York City is the same as what Peter said. We do make it available. If there are other private rulings on issue out there, you could request it. And they do redact personal information.
Okay. Yeah. This next question is one that brings into conflict different issues involved under the TBOR, the confidentiality on one side versus, in effect, due process on the other side. Taxpayer is being audited under a state sales tax. The auditor comes in and says to the vendor, you didn't collect tax on all of these transactions on all these sales transactions you had to these various customers. Taxpayer says, I thought they were exempt. Question to auditor from taxpayer: did you audit the purchaser, and was that purchaser assessed use tax on the purchases that you're now trying to collect sales tax from me? In other words, is the state double dipping on this? Is the taxpayer involved, the audited taxpayer, entitled to know whether there was an audit of the purchasers in these? State positions, look, what the positions in the different states?
It's confidential. Look, New Jersey, our goal is compliance. We want to get it right. We also don't want to double dip, as you said. But we have had situations where one taxpayer is assessed and so is the other, and they do an information exchange. You go to your vendor and you ask, hey, have you been audited for these periods, and were you assessed? And I've been in situations where adjustments have been made because the taxpayer came in and said, look, this is double, and credit was given.
So if a taxpayer has no further relationship with if the retailer has no further relationship with the customer, the state shouldn't just get the double dip then?
Well, then it comes down to, I guess, the auditor possibly looking in, but it's never going to divulge to the taxpayer. Or enter, New Jersey, there are closing agreement issues.
I know my experience has been when we've requested the auditor to do that, they just flat out refused. My experience.
Yeah, I think generally there's no taxpayer
nothing.
right
Yes,
to get that information.
No, it's not.
Now, we have one case now where there aren't that many customers, and we've been able to go to the customers and get verification letters that they have been audited for sales tax purposes, and the department auditors have accepted that as proof the tax was paid, but that's an unusual situation. If you have 5,000 customers, that's impractical.
How do you do it,
Yeah.
Right, without breaking confidentiality?
We had a similar situation. We took the position that Marlene stated that it was confidential, and what the taxpayer did was he essentially raised the TBOR issue, equal protection and uniformity with the orphans court. It was an inheritance tax case that involved a charitable remainder trust, and essentially their argument boiled down to, well, you're just treating us differently than other similarly situated trusts just because there's so much money in it. We said, no, we'll provide our division chief that administers that tax area to go through the methodology of how we assess those particular estates, and he can verify that you were treated the same way that similarly situated taxpayers were. But ultimately, they pushed the issue and they won. They won at the Orphans Court level, got an order directing us to do a fair amount of discovery related to other taxpayers. In fact, we were required to turn over, I would say, probably 2,000 or 3,000 estate files to them so that they could determine that they were treated, see how they were situated. And they were. They ended up being treated the same. But interestingly, because it involved a charitable remainder trust, the Attorney General's office was involved, and we sort of had hoped that they would take our position. They did not. They took the position of the estate, that they wanted to ensure that they were being treated uniformly. So we were required to turn that information over. It, of course, was not made part of the permanent case file at the Orphans Court level. They took it in under seal and segregated that out from the formal case file. So that's sort of how we ended up. And I think they relied on, it was the Mellon Bank was I believe, the decision that this estate relied upon to get that result.
Yeah, well, your answer, Tom, really goes also to the next question, because I know I get this question all the time from clients saying, well, I'm the only one in this industry that's ever been assessed for this. Why am I being treated differently from everybody else in my industry? Now we file an appeal, and we're arguing that we're being denied equal protection or uniformity, and how do we prove it? If the department doesn't give us the information to show how they've treated the other taxpayers or that they have treated the other taxpayers differently, we can't meet our burden of proof. And that's where the question comes up in discovery as to whether or not the department or the state is obligated to then turn over information. I would assume it's the same in New York and New Jersey. Okay, let's talk about the taxpayer advocates. Does the state have a taxpayer advocate, and what are the advocate's duties and responsibilities? And, well, we have the New York City advocate here.
Yeah. Okay, I go first then. Okay, New York State, we do have taxpayer advocate, but she's not here today. But New York City, we do, and our office is fairly new. We opened for business as of October 2015. So before that, we didn't have one, but I think the city needed because we have a lot of issues. I mean, we get a lot of complaints about property taxes, and some business owners, especially small business owners who are subject to UBT, they try to navigate through the process, and dealing with Department of Finance is like you're going in a dark room, and you don't know which door you gotta go. And sometimes you're lucky, you push the right door, you could go straight. But oftentimes you gotta go try all doors a couple times before you could get there. So I think our office was really they really needed our office. So we have taxpayer bill of rights, and as we are working through the cases, we haven't really cataloged cases by whether or not it's violating any of taxpayer bill of rights. I think going forward, we will try to categorize it. And to prepare for this panel, I did go back to some of the issues. We do categorize by issues, like what kind of issues are coming to our office more often. And one of the things that we notice is actually the biggest complaints that we are getting from taxpayers, let me just find that page, okay. If you have to summarize based on the issues, is right to pay no more than correct amount of tax, and right to quality service, right to be informed, and right to challenge the Department of Finance and be heard. Because those are the top complaints based on different issues that we look. Because first of all, like I mentioned earlier, the property tax refund, they did not know about it for a long time. A lot of people didn't even know that they were due refund. And if they did, they didn't know that it already expired. The statute of limitation applies 6 years, and it's gone. The money's gone. And you cannot claim it. I mean, after you walk up and you say, oh, I had it 10 years ago, let me see if I could go get it. No, you're out of luck. And it's because our notices didn't indicate that they did. So I think right to be informed was like one of the big one, and also the right to quality service too, because oftentimes, at least with the federal and other governments, you do have access to live person, but city requires everyone that has a complaint against New York City, or you want to inquire about how to get some service or where to go or basic questions, you have to call 311. Okay, 311 is supposed to route all your calls for whole New York City. And believe it or not, Department of Finance, all our calls go through 311. Even practitioners, unless you know who to contact within Department of Finance because of your prior dealings, but say you didn't have a lot of prior dealings with Department of Finance, you got to go through 311. And so there's a big bank of case information that will be automatically generated, then it kind of gets routed to all different agencies within the city. So by the time you get a complaint from taxpayer, it's kind of outdated. They've been asking a couple of days, a couple of weeks. So we get a lot of that. So I think since our office is open and we are busy, they call because they can call anybody else, and actually we answer live calls, and it's not a 311 system. So those things I think we have played a role in improving taxpayers' experience with Department of Finance. So I think New York City really needed, and our case volume just indicates the need for that. And as more people are becoming aware of our office, we do get a lot more cases. And since we opened, I think when our office first opened, we start out with taxpayer advocate. I'm not the original taxpayer advocate. Judge Layden was the original one. So when she started, she was the taxpayer advocate. Then we had an attorney advisor and 2 case advocates. Now, this is 2018. We now have 6 case advocates, an attorney advisor, and an admin staff who's more or less like an intake case advocate, and us. And we are still, every year, we have our volume, just an increase in cases, is almost double. It's increasing every year. And I think we are going to get more too, because our office is so new, it requires our office to go out and do outreach, meaning we are here, we are here to do this and this and this. We got to tell them what you do first. Then also for practitioners too, we have to tell them what we do. So as more people are becoming aware of our service, I think our office is going to go.
Okay. New Jersey? Oh, New Jersey.
So I just wanted to say, locally, we do not have a taxpayer advocate. It is something that my office has repeatedly tried to get the city to do because we think it would be immensely beneficial here in Philadelphia. I think we struggle from a lot of the same issues that New York City does. There's lots of different kinds of taxes, lots of different types of appeals and forms, and just navigating the system can be incredibly difficult for taxpayers. That said, we have made inroads in the code and the regulations without having a taxpayer advocate to connect taxpayers with resources. Earlier this year, we worked with the city to affirmatively get people connected with help, especially with property taxes. So instead of just handing people a brochure that says, oh, here's your rights, go figure it out on your own, anytime now someone applies for a taxpayer assistance program related to property taxes in the city is affirmatively asking people, do you want to be contacted and be connected with a housing counselor or legal services attorney? And if the person says yes, the city is sharing those names and phone numbers and addresses with an organization who is then doing affirmative outreach to taxpayers. So I think that there are ways to get people connected to resources that can advocate for them without having a formal taxpayer advocate. But I still think there would be a lot of benefit to having an actual office that is just dedicated to advocating for the taxpayers here locally.
I think
In
you
2003,
need this as an adjunct to a TBOR. I mean, a taxpayer bill of rights is not going to be any good at all and any use unless you have someone like my friend here to hear taxpayer complaints. And my experience has been that state revenue departments routinely violate TBORs. And I don't think they do it deliberately. They're unaware of the TBOR. It's not part of I don't usually have props for speeches, but I'm going to give you a prop here. This is a notice received by a client of mine this week in a sales tax matter, in which, and the notice consists of a bunch of numbers and nothing else. The New York State TBOR says that a notice like this is supposed to contain an explanation with citations of legal authorities of the reasoning and the basis of the deficiency. This letter, the letter accompanying these numbers said, you owe us $25 million. This is where you can send the check. That's not the worst thing that happened this week. We had another client that got a notice this week, again, with no explanation, no reasoning, no legal authority. And there, the amount of the check was $100 million. And I think that in order to make TBORs work, you need to have taxpayer advocates. I mean, in this case, these are big companies. You know, they have access to professional resources. But the people I worry about are not my clients. It's the low-income people who get a notice and don't have a clue as to, they've never heard of a TBOR. They don't have a clue what their rights are, and I think they need taxpayer advocates.
And even for practitioners like you, for New York City, for example, I was talking to Peter earlier about when you represent corporations, companies in New York City, because we do not have a certain collections process in place, you're very limited as to what you could do. Like, for example, we don't have statute of limitation on collections. It follows you. So if you're a corporation, when you dissolve, it goes away. But for UBT taxpayers or transactional tax and others, it'll be there forever and ever. So technically, it don't even follow you to your grave. If you die with some money or assets, you better die poor. I mean, penniless. So, no, really, that's what it's saying. And secondly, even for companies that are facing temporary hardship and they just need temporary relief, they can't get it because our installment agreement and our current offering compromise as it stands is not workable. Actually, the only way it'll work is you got to be out of business. Then there's nothing to collect. Therefore, it'll work. So there's a lot of room that needs to be done. There's another one, like reasonable abatement. We don't have real clear guidance from Department of Finance outlining what is reasonable cost. I mean, they have a laundry list of some items, but it's highly subjective. So you got to put it in writing and provide details so people know what to expect. That's for regular practitioners like you who work. Then there are other tax collection issues that oftentimes affects low-income UBT filers. So we are actually, that's part of our initiative that we are doing. We are hoping to work around business collection alternatives and providing some business relief. We did work with property hardship, so I think something's going to come down. It's going through the legislative process. So, and that's going to come to provide some relief for property owners. But I'm also looking at business tax side too. And some of the things that we are proposing, it would have to be done legislatively. But some, we could do it through providing clear guidance too. So we have mixed bag of all different things that we would like to work with. And I think that's why you do need Taxpayer Advocate's Office, because you hear from the taxpayers what's working, what's not working, what needs to be better. And I think we are in a position where we could take it, and I take it from Nina. Actually, Nina, I studied her. I said, okay, this is how, you want something done, you have to go through the process. And, you got to explain what it is now, why you need it, and how to improve it. And this is what we are proposing. And you got to hit all three different, different ways to try to get some of the initiatives through.
Marlene, I'll give you the last word on New Jersey.
New Jersey's OTA was established in early 2011. There is a specific form that you must fill out to have your issue addressed. And I happen to ask, what are the top issues that the OTA sees. And let's see, New Jersey earned income tax credit, taxpayers looking for that. They're looking for their property tax relief or senior freeze rebates, any pending refunds. Why is it taking so long? They just want an answer as far as refunds. Abatement denials regarding penalty and related interest. And as a division employee, you don't want to have an email come from OTA into your inbox because it's like, what I do wrong. But I will say, it does, as as an agency representative, I think the Office of Taxpayer Advocate keeps me, as far as doing the correct thing, making sure that taxpayers understand what we're doing and compliance, without the division. So I think it helps me and my branch.
Okay. Thank you. According to the clock on the back of the room, it's now 12:31.
Okay.
And with that, I'd like to thank our panel.